Start. Respondent number 1 issued a notification under section 4 of the Land Acquisition Act, wherein the entire land belonging to the petitioner, including the land which formed part of the sealing proceeding as aforesaid, was a subject matter of that notification, full stop. On 8.2.1990, notification under section 6 of the Land Acquisition Act was also issued, full stop. The declaration under section 4 and 6 was challenged before the High Court in writ petition number 5462 of 1990, which writ petition was allowed on 20.8.1983, and the declaration under section 6 was quashed, full stop. Under section 6 of the Land Acquisition Act, the land of the petitioner was shown to be included in the said declaration, full stop. Consequently, award was made on 29.2.1982 and on 7.2.2001, which was challenged before Honorable High Court and was dismissed by a division bench wide order dated 5.1.2000, full stop. The special leave petition was filed before the Honorable Supreme Court by the Agra Development Authority, and the award was amended as per order, and the amended award was published as per order of the Honorable Supreme Court, full stop. The petitioner's land, which was subject matter of the proceeding under the Sealing Act, was never transferred to the state government, nor any position with regard to the same was taken by the state government, full stop. It is apparent from the possession certificate dated 30.3.1991, full stop. This possession was acknowledged by respondent number 3, who directed the petitioner that since the compensation has been paid to the petitioner by mistake for the entire land, the same may be refunded by the petitioner along with interest for the land measuring 1 bigha and 5 biswas, which does not form part of the acquisition proceedings, full stop. The petitioner approached respondent number 3 for depositing the said amount, but the said amount was not accepted, and therefore he approached respondent number 1 by means of representation and requested respondent number 1 to release the land in favor of the petitioner, and whatever compensation was received by the petitioner was directed to be refunded to the respondent number 4 through respondent number 3, full stop. The said representation of the petitioner has been rejected by the respondent number 1, full stop, para. The state government filed its counter affidavit denying the averments as made and filed affidavit of Shri Babu Ram, Under Secretary Awas Evam Sehkari Niyojan Department, Government of UP, while denying the contentions raised in the writ petition. It is submitted that in notification under section 4 of the Land Acquisition Act, the petitioner's plot number 460 was included, and subsequently notification under section 6 was issued, full stop. The urgency clause was invoked, full stop. The contention that sealing proceedings were ex parte proceedings and notice under section 10 in bracket 1 was not served is denied, full stop. It is contended that due procedure regarding Sealing Act was followed, and at this stage they need not reply, full stop. It is further contended that possession memo dated 30.3.1991 shows that possession of total area of plot number 460 have been handed over to the Agra Development Authority, who is at present in actual physical possession over the plot, along with other plots, full stop, para. Against the averments made in the counter affidavit, comma, a rejoinder affidavit has been filed on behalf of the petitioner wherein the contentions raised in the counter affidavit have been denied, full stop. It is contended that till date the plot number 460 is not transferred to the state government nor any possession was taken, that before after questioning of the declaration under section 6 of the Land Acquisition Act by the High Court, fresh declaration has been made on 16.1.1995, full stop. The petitioner is still in actual physical possession over the plot number 460 and the possession was never obtained by the state government and the excess compensation paid to the petitioner may be refunded with interest for the land in question, full stop. Order dated 28.3.2008 is not sustainable in law, full stop, para. This court went into the question as to whether interlocutory injunction of a mandatory character as against the prohibitory injunction could be granted, question mark. The counsel for the respondents pointed out that the mandatory injunctions were essential to avoid greater risk of injustice being caused, full stop. There is no difficulty in accepting that this court did accept that test, full stop. The relief of interlocutory mandatory injunctions are thus granted generally to preserve or restore the status quo of the test last non-contested status which preceded the pending controversy until the final hearing, when full relief may be granted, or to compel the undoing of those acts that have been illegally done or the restoration of that which was wrongfully taken from the party complaining, full stop. But since the granting of such an injunction to a party who fails or would fail to establish his right at the trial may cause great injustice or irreparable harm to the party against whom it was granted, or alternatively not granting of it to a party who succeeds or would succeed may equally cause great injustice or irreparable harm, full stop. Courts have evolved certain guidelines, full stop, para. Over. Sorry.